Yes, ma'am, it is
Okay.
starting.
Yeah, recording has started. Okay, so thank you all the students for taking out time to come for this fourth semester counseling. And first, I would also like to thank RC Delhi-2 for taking this responsibility of organizing the counseling sessions for the third as well as the fourth semester. It's quite a Herculean task, and they have really done a great job. And their Dr. Rita is there and her team. Thank you very much for all this. And thank you, Dr. Lakshmi Prasad, for taking this. I think, Rita, this is the first fourth semester counseling session that we are having. So we, unfortunately, for because of being the teething problem and the first batch, the third semester, those people who are now in fourth semester, in your third semester, we couldn't really organize some classes. I think one or two only we had. So we are having third semester classes also. Those of you who have not appeared in the exam and wish to take third as well as fourth semester classes, you are most welcome. So I welcome Dr. Lakshmi Prasad, who is Head of Department Hospital Administration in AIIMS Bhopal. And for us, the more important introduction is that he is a great writer, editor, and now a counselor who has been associated with IGNOU since the conception of this program. And he is also one of the coordinators for our very important center in AIIMS Bhopal. And he's a wonderful person as a person, and he's a very meticulous administrator, and I'm sure that there will be a lot of things to learn from him. So my request is that please make active participation. Do not interrupt him. If you have some very important questions which can't wait till the end, then maybe you can. Otherwise, please either write in the chat box or keep the questions for the end. Dr. Rita will be moderating the session and she will allow you time for questions, and that is how it is. So with these words, Dr. Lakshmi Prasad, I would request you to start your class. Thank you, sir.
Thank you, madam. Thanks for your kind words. And I thank New Delhi RC for organizing the event. And welcome to all the learners. So to start with, you have all chosen to be in the hospital management or hospital administration as a kind of a learning endeavor, or maybe in the future you may be taking as your very kind of a career prospect as well. So first and foremost thing, when it comes to hospital management, so the law of the land. So whatever laws that are applicable and what is the basis for that laws, how to interpret them, how to comply with them, that is one essential aspect for anybody who is pursuing this course must know. So as you know, the MHM course, the MBAHCM course, there are just certain blocks are there in terms of reference material that is being provided with you. One of the block is on legal aspects in healthcare delivery system. The legal aspects in healthcare delivery system, again, it is having 3 units. That is constitutional laws, regulations, rules, and legal medicine. That is the first unit that we are dealing with. So the very first slide here, it highlighted legal foundation every healthcare administrator must know. That signifies the very importance of this particular unit for all the, whoever joined the course, and particularly whoever has participated today to be online, so that in this session of next 1.5 hours, where 3 units are going to be completed. So we'll be having a presentation at the same time. Whoever would like to interpret also, they are most welcome, and so that we can have a interactive kind of session. So constitution to start with, then how other things are derived from everything, whether it is laws or regulations or rules, everything is derived from the constitution. So what are the medicine practice that we are doing in the healthcare establishment, as a kind of a company or as a kind of a hospital or a charity institution or as a medical college institution, wherever the medicine is practiced, that to be as per the legal provision. That is what legal medicine. So how it applies to these establishments and these professionals, that could be doctors, nurses, or whoever is doing. So how it is applicable, that is what we are going to learn and we are going to witness in the next few slides. So the learning objective, IGNOU material always laid with a beautiful kind of layout, wherein learning objective at the very beginning of the chapter, very beginning of every unit, they laid out in such a manner so that the learner will be always can keep track of what they are learning at any point of time, and even the person who is providing the counseling also, they can stick on to certain framework. So why law matters in healthcare? So healthcare cannot not existing in the isolation, that is part of the larger framework, that is the whatever constitution which has come into existence. From constitution, all kind of criminal and civil laws has come into you know effect over a period of time, how they are there. That is all we are going to see. Then fundamental rights, federal system, that is who is responsible. We have a state government, there are medical college, we have a central institutions, and there's a DGHS, and at state level you have a direct medical education, direct medical health services. So there's a state role is there and central role also there. That it broadly speaks about the federal system and separation of the powers. So powers is that a kind of a sovereignty. The kind of power is a, a kind of a mandate for them to impose what is being constitutionally acceptable and which is enacted by the parliament or a state legislature as a law. And from law, again, you will be derivating few regulations, few acts, few rules. So that is all about federal system and separation of powers. Constitution articles. So how constitution is a basis for the healthcare setup in India. As you know, there is a kind of fundamental rights. So right for life is there. So right for life is how it could be possible without having a proper healthcare system and regulated system. So there comes the very constitutional basis for the healthcare that is being extended in India. So Article 21 is there. So that is serial number 6, as you could see. That we'll be elaborating as we go through next few slides. So how any law is being enacted. So biomedical waste rules, sometime back, they are not there. PCPNDT Act, it has come into existence sometime back. So over a period of time, MTP Act, maybe in 1978. So several laws has come into existence over a period of time. How any law, how it is being promulgated, how that is being implemented to the mechanism of law and enforcing agencies, and how they are interpreted to the judiciary mechanism. So, they are the four pillars of democracy. That could be legislative, that could be executive, then the kind of press is there, then one more organization is judiciary. So all those four are very fundamental for very survival of the civilized society. The civilized society is runs on law in accordance with the law. So law formulation process we have to see. Then what is the differences could be minute differences, how laws are promulgated, where does regulation stands, and what does it mean by rules. Even in apartment, apartment will be having a bylaws kind of thing. So what is the role of bylaws, whether they are legally enforceable? These things we are going to see in the next slides. Then legal medicine and hospital liability. This is a core part of our discussion today. Then case judgments. So all, not only the legislative houses there at the state government level or at the parliament, even some of the judgments which are promulgated, which are being issued by the courts, Supreme Court or High Courts, they also constitutes part of the compliance which a hospital administrator is supposed to ensure. So that is case judgments. So this is the kind of framework for our discussion in the unit 1. Then as we start with what are the kind of this provision of this particular chapter, please hold on for a moment. Just sorry to say that. Hello, please. Yeah, 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 yeah. So I'll get back to you on the same number, maybe no. Please, I'll get back to you. Thank you. Thank you. Thank you. So now let us go to the next slide. So understand the structure of Indian Constitution and its relevance to the healthcare governance. So as you know, our Constitution has come into existence, which is being adopted in 1950 on January 26. But it is been finalized and accepted in November 26th in 1949. So under the structure of Indian Constitution, we need to see which are the things that are applicable for the healthcare setup. So the structure is broadly we can understand it is having several articles, 395 articles are there, whereas we talked about Article 21, which is providing basis for healthcare as a right for the human beings. And again, the constitution is divided into some 22 parts and several schedules are there, around 8 schedules, which actually makes up entire constitution. The constitution, as in the earlier slide, there is a kind of a federal naturality there. So everything is there between the state government and then the central government. So health basically it is coming under state government, but certain parts of the health related to public health related, they will be under the concurrent list as well. So then there was a Panchayat Raj related one act was issued, amendment of the Constitution Amendment Act 1972 or so, or 72 or so. In that even the municipalities is having a major role when it is coming to healthcare related and any public related issues. So the Constitution, what we need to know, the entire Constitution, what is the idea? Constitution makes the India as a sovereign country. So India will govern by its own laws. The laws are promulgated in the legislature where people representatives are there. Our member of parliaments who are voted to power, they go to the parliament. Our member of legislative assembly, which are again voted by the public, they go into the legislative assemblies at the state level. So in turn, they have the power to make the laws. Okay. So the laws, once they are submitted, so there could be private bill, there could be kind of government bill. Private bill is any kind of individual, a need not to be party in the power. A single MLA or member of parliament, they also can introduce a bill that is called private bill. Public bill is a kind of thing where government in power. So one of the minister is going to propose for the environment sustainability. This is the bill that I am introducing. Once the bill is passed in the particular legislative house, as per the constitution provision, that is having a simple majority, that is more than 50% is saying okay, or some of the major laws require 2/3 of the majority, people who are attending and who are accepting. Once that is happens, that is going to become a law in itself. So coming to fundamental rights. So these are the 4 learning objectives. Each one we are going to deal with. So distinguishing between laws, regulation, concept of legal medicine, analyzing some Supreme Court related judgments. So legal awareness. So as it has been mentioned at the very beginning, we operate in a system where everything is governed by the law that has been in existence. So the kind of municipal related laws, company laws are there. So corporate hospitals are there, they fall under the company law. Then medical practice, medical legal related laws are there. So there is a evidence law, the kind of consents how we are supposed to take to the patient. Then there is a organ transplant act. So all these kind of acts, PCPNDT, you know very much. So every act is having a huge impact on the hospital. So which is related to very existence of the hospital. So whoever happen to be hospital administrator, they have to maintain a tracker of laws, which the statutes, which the hospital has to abide by, which is being valid up to which date, and what is the time on which they are supposed to apply, because 3 months before expiry of the existing license, you may have to apply. Some of the states is having lift related license also they are requiring. So which are the things that are applicable? Some 200 plus licenses are required in operating a hospital. So all the things one should be knowing. So the dictum is ignorance of the law is no excuse. Every administrator, doctor and nurse is accountable under law. Even MTP Act also says up to what age that a MTP can be conducted. If it has to be conducted, what kind of training a doctor supposed to have, in what kind of setup they should be doing. So everything is been in black and white. So there's no scope for anybody to play outside the framework. So the very purpose of law is to protect the patients, the service providers, and the very larger society. So why I can say larger society? During COVID, what happened, you all know. During COVID, there was a quarantine. So people movement was restricted. What was the basis? How the government has that power to issue restriction orders to declare that it is quarantine, so people cannot move freely, or they cannot assemble. So in the good intention of preventing the infection transmission, so there is a kind of epidemiology act. Way back in 1897 or so, it has been enacted. The Indian Epidemiology Act. It has been enacted in 1897. Can you imagine? The act which was there about 130 years, that act was coming to handy to tackle the COVID. COVID was tackled using the Epidemic Diseases Act of 1897. So why the act was promulgated? Because there in the Bombay that time in 1897, there was a bubonic plague. Plague, 100 years, 130 years back, due to unhygienic conditions or whatever the reasons, plague was such a kind of a lethal where thousands, lakhs of people used to die. So that time, to minimize, to ensure the cleanliness, to ensure proper sewage treatment, to ensure the prevention of the disease. So such kind of calamity, that act has come into existence. The same act during COVID time has come to our rescue, apart from several other measures. So that is the idea in the kind of context for every administrator and nurse to know about the law. So rising litigations, now there is a kind of a consumer and provider relationship. Okay, so it is not a kind of a charity. It is not a, of course, there is a service aspect of even software is a service. Like that, healthcare also service, but you are charging a fee for that. So there is a consumer related, a kind of a relationship being established. The moment you collected, even the user fee is collected, even a government hospital user fee. So there is a kind of a huge repercussions in terms of legal matters when somebody goes for the litigation aspect. Then digital and AI era. So it is always dynamic kind of thing. Technology has come into existence in several modes, and we are witnessing at this point of time the electronic health records has come into play, so that they are going to assist and they are going to may change entire landscape. So if artificial intelligence, if it is giving the decision, you are taking the decision, but you are implementing, isn't it? So if patient is exploring AI and if he is using, he only responsible. But as a doctor, whether you refer to any textbook of medicine, say Davidson or Hudson, and still it is being practiced by you. It is being prescribed by you. Likewise, AI also, you can use any kind of technology to assist you in making decision, but you are responsible for the outcome. So how to use, to what extent, that is maybe where all should be in a learning phase, and we should not be missing the revolution and the kind of opportunity. Then organizational duty. So as individuals, whatever we are doing, that is always there. But as an organization, when we establish, we employ the people, what is the minimum kind of wages? Okay, what are the kind of GST returns? What are the applicable kind of rates? So everything, what is the kind of, whatever the import related things and medication related laws that are applicable in terms of narcotics license, everything. So all these kind of acts, again, organizational wise, we have to be complying with. So as a hospital administrator, most of the time it is not a private practice, no, unless you go for the consultancy. It is not a private practice. We'll be part of a organization where we may be having a support of legal professionals once the issue is being properly been comprehended by the hospital administrator. You have a clinician with you. who is the proprietor, or you have a non-clinician who is an entrepreneur who started the hospital. But as a hospital administrator or a hospital manager, if you are there, finally you need to see what kind of information that you should be providing so that the facts could be represented to the not to the beneficial to you, at least which are actually factual, which should be known to the kind of people who are supposed to be adjudicating over the matters. So there comes your organizational duty. Then coming to the broader way, the number of articles that is being told, this is a constitutional structure. Constitution is the supreme law. So any law, any parliament, or any kind of you know legislative assembly in any of the state, or even any ordinance that is being issued by any governor, that should be within the framework of the constitution. So who is going to say whether it is within the framework of the constitution or not? That is the Supreme Court. Interpreting the constitution is within the very much scope of Supreme Court. Okay, so the judiciary role is ensuring that legislator house is formed by the party in power, and the parties, recently we had elections, several parties come into power, on alternative terms, maybe 5 years one party, another 5 years another party. But as a country, the the guiding principle is constitution. So if any of the parliament in one particular sitting with one kind of majority, maybe let us say brutal majority, they want to fundamentally change, they want to say next 10 years there are no elections, so the same party may continue in the power. I am giving a crude example like that. If such law is passed with a required majority, so whether it is constitutionally valid in a democratic country where universal adult franchise, irrespective of financial position or educational qualification, within 18 years, one person is attains 18 years, irrespective of financial, gender, or religion, without any discrimination, it is a universal adult franchise. So if 5 years, if they need to, use their kind of judgment to bring a party into power or to throw out a party out of the power, if this kind of legislation is passed, so court is going to agree? No. So there the supreme law is always been maintained and protected by interpretation and scrutiny of the Supreme Court of India. So any other law that should be always be consistent with, should not be inconsistent, should be consistent. So there's a kind of, you have given the vote to the central government when it comes to parliamentary kind of votes, that is elections are happening. So then you have given state government as well. Then both of them are there to rule, to make the legislation. So government of India, in the constitution itself, it provides which are under the union list. The government of India can only make acts related to defense, isn't it? Related to external relations, external government, how to be with the government of any other neighboring country, with China or any other country. So these are the kind of, say, postal and telegraph, railways. These are the things comes under the union list. So part of it could be there related to health as well. So that is related to public health, where the common good across the country which are applicable. Then comes to state list. So here public health, hospitals, sanitation. So majorly it is health is coming under the state legislation. So AIIMS is there across India. All the AIIMS are being governed by central government to the Ministry of Health and Family Welfare. Though AIIMS are autonomous, so there is a act that is promulgated there in the AIIMS Act in the Parliament. That AIIMS Act again revised so that new AIIMS can be formed. Though it is coming under the union list, still there are other several establishment, majority of the establishment which are under the government, that falls under the state list only, where state government can come out with its own laws. So there is a concurrent list. So dental profession, drugs and all, so drugs related to that extent, I think both the governments, whether it is central or state, both can legislate. This is the constitution overview, which is adopted in 1949 on 26 November and enforced from longest constitution. So there's a fundamental rights. So once you say Indian citizen, you are privileged to have these kind of rights: right to equality, right to freedom, right against exploitation, all the things there. But our interest is right to freedom is where Article 19 to 22, wherein 21 is there. That is exactly related to right to life. From there, government responsibility comes. So government responsibility, to what extent it is there, that is being clearly defined under fundamental rights. So where nothing can be denied. Supreme Court will protect our fundamental rights. Then there is a kind of a directive principles which has come into existence in 1976 to the amendment of Constitution, 42nd Amendment of the Constitution. So it is a welfare state. So government need to see people's welfare by acting accordingly, rather than concentration of wealth, rather than survival of the fittest. So everybody, whoever is the Indian citizen, the government acts and legislation should be having some direction wherein these people and these situations could be mitigated and they should be protected. State to secure social order for life, Article 38, right to adequate means of livelihood. Why the Minimum Wages Act is there? So why there's a kind of, so people who are working in the radiology department, they need to have special leave, isn't it? So maternity leave people need to have. So childcare leave people need to have. So all these kind of things, they are derived from the constitution as the directive principles were, you know, in 1976. Though original constitution is there from 1950 onwards, so time to time with the changing situation, amendments to happen. So that is the beauty of the constitution. Constitution is not something which is meant for ruling. Constitution is meant for people to live and adapt. So that is why constitution is always dynamic in nature. So though ours is a written constitution, time to time the amendments to happen, and Supreme Court, as long as that ratifies, it doesn't intervene saying that controversy that is against the law, like that, if they don't say what are the amendments that are justifiable. So just on human conditions of work. Just now we talked about radiology department, all the things. So rising nutrition, living standards, improved public health. So these are the directives. So welfare society means what? What does it mean by freedom? So how you rule yourself to your own constitution, for the people, by the people, to the people, if you say. So these all should help the people. So that's why directive principles have come into existence. So healthcare related constitution. Now you come to this particular aspect. So right to equality, that itself says then there's a kind of a provision for the healthcare that government should be providing equal treatment in government hospitals, no arbitrary refusal. So you would have seen wondering why there is a floor bed. So हमारे पास बेड नहीं है तो भी पेशेंट को क्यों लेना पड़ेगा? Somebody may be wondering why it should be so. But it is always the patients can be stabilized, patients can be referred to other hospital. But every hospital, if it is more than its occupancy, if it is running, and if the patient is coming for the cure. Next aspect is care. Next aspect is comfort. So if the cure, if you are extending the relevant intervention, the ailment whichever been they are suffering from, so even the bed is not there, if the ideal situation is not there, still you cannot avoid any patient. Okay, so there comes some of the judgments, even the private hospitals, when it comes to any patient approaching, why we have to Paramananda related one case is there. We'll go to that. Right to life and personal liberty. So it is interpreted right to health. So this is the important slide for this particular unit, apart from the judicial interpretation, one of the last slides. So prohibition of trafficking persons. So healthcare settings, whatever the employment and everything related, and children labor. So it is applicable to all the industries like healthcare industries, welfare state, healthcare infrastructure. These many aims have come up, these many medical colleges. So now here, literally 1,20,000 medical graduates were coming out every year from allopathic system alone. Okay, I completed my MBBS in 1993, whereas I joined in 86. So that time 7,000 medical seats are there. 7,000 has become so 1,10,000 in last 30 years. So always healthcare infrastructure is always about the kind of government establishments and government academics like institutions and that kind of training, the vaccination, all these kind of provisions, whatever that is government is providing. Health workers protect health and strength of employees, right to public assistance, sickness and disablement. So even ESI Act, that has come into 1948. ESI Act has come. So that is all kind of workers and everybody from the disablement. If they get employment related injury, even though it is mainly for the health only, ESI hospital, still they will be getting the required compensation by virtue of their contribution which they were making. Duty to right nutrition. So even NABH, so nutritional screening is happening to all the patients who are admitted. So all these aspects in one way or other way, they're all part of our healthcare industry. To the extent that is feasible and practical, they have been, you know, included here. They are fundamental duties related to our social behavior, that is value of the health, it could be. So the right to health, Article 21 is further elaborated. So in the Paramanand Katrao and versus Union of India, duty bound. So a patient has been uh, referred to one hospital to other hospital, 3 hospitals he has been to after involving in a road traffic accident. Then government of India was being, sued by the concerned, individuals or concerned socially vacant people. That led to Supreme Court to say any hospital, whether it's a private or public, is duty bound to provide first aid for the accident victims. It cannot deny. It is duty bound. After that, you can refer. After that, you can do anything. But first step is you have to start with whatever you are supposed to be as a healthcare establishment. So there's a Pachim Baga Khet Mazdoor Samiti. So there some at the railway station somebody was met with an accident, and there's again a kind of several hospital turning down the patient. So again the same thing was strengthened, which is the real spirit of Article 21, life of right to life, to the 2 consecutive cases that court has come across in 1989 and 96. Finally, it has all been integral to the, in one go, it has been told in 1995, Article 21 is nothing but right to health, which is fundamental to ensuring the right to health to the individual, which is the duty of the government. That is how it is being solidified. Now it is no more interpretation. Now it is a kind of 100% has come into existence. No person shall be deprived of his life or personal liberty except according to procedure established by law. So what does it mean? People are imprisoned. There could be hanging kind of, terminal kind of issue will be there. So when it comes to court judgment, terminal kind of conviction where people may be hanged. So that those are the different things. Otherwise, except according to procedure established by law, everybody is having a right to freedom of personal liberty and nobody deprived of the life. So then Supreme Court has interpreted life to include right to live with human dignity, which so right to health is a very much related to dignity. So that's why we always, hospital beds to patient ratio. So in the developed countries, for 800 patients, 1 bed is there. In India, how many is there? Some countries, 60 patients are having 1 bed. India, how many beds? Doctor to patient ratio, how much it is there? So in your hospital, nurses to bed ratio. So general ward, you need to have 6 to 8 general ward beds need to have 1 nurse. In ICU without ventilator, 2 beds can be taken care by 1 nurse. 1 nurse can take care of only 1 ventilated patient. So all the things in one way or other way leads to our practice. So then how a law is made, the proposal, as I said, as a bill in the form of bill that is being given, submitted at the legislative assembly at state level or parliament, then the cabinet will be approving, then parliament will be enacting the law. As the parliament, it will be submitted, and as the law is passed, Then India is, though it is still we have the presidential system in there. So president is going to give the officially he is going to sign the bill so that it is come as into the existence and it is enforceable. Then before it is enforceable, so public will be notified through the gazette notification. So all the rules and regulations which are comes into existence, they are nothing but the source will be final rules how to operate it, all these kind of thing based upon the parent legislation. The legislation gives the framework. Within that, all the regulations, all the rules, all the bylaws has to be there. So type of bills, private member bill by any MLA or MP can introduce. Money bill only related to financial related, that is time to time. Constitution amendment bill, that is different. When it comes to any of the bill, it is only two types, that is private member and public bill. Hospital management drug gazette notification. So any kind of interpretation is not required when it comes to gazette notification. That is clearly speaks for the what is government intention, what is the acts of our omission or commission, how we are bound by the particular legislation. That will be there in the notification, original notification. So laws, regulation, rules. So law is enacted by parliament and regulatory bodies, not MCI anymore. Regulations are, so what should be the qualification for that? Medical college teacher. That is released by NMC. So earlier it was by MCA. So that is regulation. So based upon within the kind of qualified people only has to treat. So the rules, so then again it is being implemented by one of the departments under the ministry. So how to implement, that is what talked by, that is what meant by rules. The implementation part is rules. So our hospital rules are like this. So then the bylaws can be government or private or anywhere. These bylaws can be uh, they are being practiced and they are enactable. So who is going the authority? What is the scope? Nationwide or statewide or local or organizational or a housing society? So this is all talks about this particular slide and how it could be enforceable. So enforceable locally or enforceable across the court. So this is a kind of, when it is a law directly court, when it is a kind of bylaw, what are the adjudicating mechanism, review mechanism, step by step, again it can go to court, but you have several steps to follow. Then different healthcare related law, Indian Medical Council. So all acts again the laws, but all laws cannot be acts. Law is a much broader. So that's why some of the laws and acts both could be one and same also. That is how the book defines. So hospital visiting hours. So a hospital can define by as per its own bylaws. So in the interest of the overcrowding or avoiding the theft or infection, all the things to prevent, to manage your premises in a better way, hospital can have its own bylaws related to visiting hour. Our policy related to visiting hours. This nobody can question that, isn't it? That you can make out. So by prescription, the penalty, any law that is violated, that lead to kind of a penalty. And hospital also, you can say what are the fines that you are going to impact, unless somebody challenges that they are being complied with. So everything comes under the finally constitution is the supreme law. From that supreme law again individual laws. From that individual laws, the acts, regulations, rules, bylaws, they are derivatives of that. So legal medicine. So it is a legal medicine is the application of medical knowledge and to aid legal investigations and to uphold justice. So whatever the forensic medicine, whatever the MLC that you are doing in your hospital, so this is all about complying with our professional obligation towards the larger society and as per the law. So the aims of the legal medicine is enumerated here: sound medical practice and protect patient rights. So patient right is safety. Safety is a patient right, isn't it? So all these things, how we have to comply with. So all the things are part of this particular slide. Court with medical experts. So when you are summoned, you are supposed to be with all kind of your opinion, which is having a basis. You are supposed to be providing. So then, what as a doctor, what is? So we talked about the professional responsibilities. So responsibility could be safe care, not to deny the treatment, taking the proper consent, you have the accountability, protect healthcare professionals from unjust. So the laws is not meant alone for the patient. It is to support us, the healthcare professionals as well. So laws will weigh. So as you know, if somebody goes against you to the, you have to prove there is a kind of a deficiency in the service from the hospital side or individual doctor side, isn't it? You need not to prove your innocence. So they have to prove that you are at fault. The standard of care not been maintained in terms of in terms of standard treatment guidelines. Okay, this is the standard treatment guidelines. These are the possible adverse reactions. So you are not being intimated. You have the kind of possible anaphylaxis reactions, and you are not being given the test dose. So these are in one way or other way we are all know and practicing also. But here the objective of this particular unit is to bring in a structured manner for us to address the very essential of our healthcare profession. So promote ethical standards. So there's a huge research related and all the medicines that are coming to existence. There's a commercial aspect of our profession, and whatever the inputs that we are getting in terms of medicines or consumables or kind of diagnostic services or therapeutic interventions, there's a kind of a ethical aspect also. So what are the ethical standards we should follow? That is again a kind of how they could be. Ethics are collective kind of thing. Morality is individual. So how, as an institution, ethical practices we should be following, and other related things we already talked about, healthcare compliance areas, environmental. So if you say biomedical waste properly to be managed, not disposed, to be managed, you cannot dispose biomedical waste just like that. You have to segregate. Then you are not supposed to not only dispose, you cannot even treat the biomedical waste. There's a common treatment facility. One agencies will be there in your city, in your town, where to whom you have to hand over the biomedical waste. They'll be having the facility in terms of incinerator. They'll be having the facility in terms of whatever the effluent treatment plant or all kind of microwaves or autoclaves where the waste is being made a kind of a non-infectious even before they are going to landfill or finally whatever mechanism they do, because before to that they have to make your infectious waste which you have segregated into yellow or red kind of different bins as per the biomedical waste management rules. So that is a environmental kind of thing. So electronic health record, data privacy, so medical record, whatever it is, whether it is in a digital form or whether it is in the existing medical record manual form. So it is all related, not about you alone. Whatever the treatment you have given, you are giving under contractual obligation to a patient. So how you have given all the data privacy. So that is again is enlightened here. So working hours, wages. So wages. So you may have a daily wage. Daily wage labor has to be paid at the end of the day. You may be having a contract wages wherein on monthly wages you are paying. So on seventh day of next month, the previous month's salary you are supposed to pay. So if it is fortnightly payment, if you are doing on 16th day, you are supposed to be doing. So after 15 days old. So everything is defined in the law. So the consent is informed consent, the records, the protocols. So one blanket consent you cannot take. So one consent is for treatment. Then again the consent is there for blood transfusion. The consent is there for the surgery. The consent is there for the dialysis. The consent is there for whatever the thing. If somebody wants to donate organ donation, they will give their own consent in the whichever forum that form is applicable. So everything, as a doctor, it is not that you are cleared your exam, so you got your register, your qualification. Then it has to get registered. Then time to time you have to maintain your conduct by attending the required number of classes and a professional conduct that is again comes under the NMC purview. So all the things are being defined in law that has to be adhered with. Then hospital liabilities, administrative liability, proper records, inadequate staffing, supervision. So if we, whatever the safety related, everything, fire safety, all the things, fire safety week, last week only been observed across India in all the hospitals and all kind of establishments. So professional liability, individual doctors, nurses, a minimal level of care, Bolam principle, one principle is there, BOLAM, Bolam principle that you can refer to. So it is not a expert care. It is standard care. Minimum standard care if you don't. So we all say civilized manner. Civilized manner means not about pampering of anybody. Civilized manner is a kind of a courtesy, mutual courtesy. So likewise, a standard of care that is again a professionally it is is expected. Then the consent. So there's a consent is given, informed consent. Informed consent is patient know pros and cons. What are the possible risks with the kind of the treatment that you are offering? What are the possible benefits? What are the possible alternatives? At that point of time, as per the evidence of the medicine that is available in the existence, which is better as per the doctor opinion, then you will be choosing which you want to go for. So all the things informed consent doesn't imply one signature of the doctor, one signature of the patient, and one witness. So how to actually put into practice? Failure of follow-up standard care, hospital, then vicarious responsibility. So you employ everybody so that you can run the thing. So my fire safety is completely been taken care by my fire engineer or supervisor. It is not so. As you know, whatever the hospital fire incidents, Amri Hospital, people quote always, the hospital, all the directors were arrested. So though they may be having a fire inspector or fire engineer, anybody, any doctor, you apply for any kind of patient care. So whatever the kind of responsibility, always it lies with the management and the main doctor. If you are having a trainees in a medical college or somewhere, again you are respondent superior. So always the responsibility lies with the superior. Let the master answer for servant acts. So these are the dictums. Apply even if not being aware about is something not acceptable when it comes to legality. Ensuring sound practice, follow protocols, maintain record, obtain consent. These are the minimum things, which makes you be in the safe kind of mode rather than getting into problem. So importance case judgment, Farman Katra, consumer education research, Pachim Bengal, common cause. So these are the case judgment which we already talked about, wherein the duty of the hospital is always to provide the life-saving intervention at the time of need. Okay, so that is the glossary. This is the last slide for this particular unit. So vicarious responsibility is ipsa lacutor, that is negligence. So if you rest say ipsa lacutor, if the doctors are there in the audience, the forensic we read this. So the thing speaks for itself. So you have done a surgery and some gauze piece you left in the body. Okay, what happens? So gauze piece on its own doesn't enter into the body. So you have done a surgery. So the gauze piece leads to kind of infection that led to septicemia that leads to death. Then post-mortem they found out. So what is happening? Here there is no defense. The thing speaks for itself. That is the meaning. So directive principles that we said, that is the guiding principles for the government. Okay. So this is the first unit. Now let us have the key takeaways. Constitution is supreme that we talked about. Legal framework, that is local, state government, central government. We talked about gazette notification, hospital liabilities broadly in terms of employees, in terms of facility we talked about. So now it is open for the discussion before we go for the unit 2 under this particular block. Please, letter.
Thank you so much, sir. I
Yeah.
think this is a very good opportunity for asking questions. Please ask the questions.
Good evening, sir.
Yeah.
Yeah.
So my
Please.
question is regarding the professional indemnity which is there to protect the professional act. So in that case, like it supports the hospital or the doctor alone.
No, professional indemnity insurance is all about financial compensation when it comes to. Okay. It a kind of a criminal negligence, these things are not being covered. So if a court under law of torts or a consumer protection act, if there is a kind of a penalty, then the compensation, like our vehicle registration, third party, the kind of registration, the vehicles insurance, what we take, basic minimum registration insurance our vehicle should be having, so that whoever been aggrieved in by the way of any accident or something, the insurance company is going to compensate. Like that professional indemnity, if a hospital would like to take, then it will say for 500 employees up to 50 lakhs rupees, whichever the employee been involved. These are my 500 employees. Employees data also need not to be there. But while the case has been lodged by aggrieved party by your name, if there is evidence that you are on the rolls of that particular hospital, and hospital is paying the premium, and the policy indemnity insurance is being alive, you are automatically covered. Your whatever the act of commission and omission that is leading to awarding of the penalty, you are being covered. But many of the now with a hi-fi kind of environment and corporate hospitals being there, fraction of their earnings, they take they take their indemnity insurance by paying the whatever the premium. So that premium actually covers whatever their private practice, whatever their practice associated with any of the corporate hospitals they are visiting. So either way, who is paying the premium is not the question here. So it is evident that as you pay premium, you are covered. And as you pay premium, wherever you do practice your profession, under whatever circumstances that led to that kind of penalty, again it is covered. So you have not taken, you are not into individual practice, but the organization which you are associated with, they have taken for these many employees. So under those many employees, you have a ID card, you have a last month's salary that is been distributed to you, that is been there, that is always been covered. That is advisable also. I wish maybe further any clarification you would like to ask, please ask.
No, sir, you answered it nicely, sir. I just wanted to know, like, it is only covering the compensation part. What
Yeah,
about
yeah,
what
of
about the
course. Yeah, only compensation. Even motor vehicle insurance, whatever it is taken, so it doesn't cover about the negligence on the part of the driver. Let us take what we know, so that we can speak about what we don't know much of the extent, because hospital related negligence, the penalty, once in a blue moon it happens, the kind of imprisonment, the kind of criminal negligence. But vehicle related, daily we come across how many accidents are happening. So it is a substitute to only the pecuniary aspect, the financial related burden only, that is being taken off out of your burden. Rest of things, when it comes to whatever the criminal negligence, all the things, that is nothing to do with any kind of insurance. We are not insured from our liability in terms of our criminal law kind of thing. Only financial compensation only covered.
Thank you, sir.
Please, thank you so much. Otherwise, we all can imagine a situation. So anybody can practice any medicine. Okay, say a surgeon can say, sometime back, 30 years back, I was neurosurgeon also. Today, how I cannot be. So I was doing. So I can take the insurance if any time some kind of malpractice suit is there beyond my specialization I am doing. So maybe 30 years, 20 years back, it is okay. Now it may not be okay. Now every special super specialty being into existence. So the scope of service of the hospital, you are not under your scope of services, you don't have a Bunce case. But not only you are stabilizing the case, but you are continue to treat without having the minimum requirements being met. You don't have a plastic surgeon, then still you are continuing with the case. So maybe how it is been interpreted, that is there comes in, a law is always subject to interpretation, but fundamentally, which side we are there, and we should be on the right side of law, and being cautious is always advised. Yeah. Further discussion, please. So we have time up to 5:30. Some of you must be private practitioners as well. So I think only one unit that we have covered.
Sir, would
So
you want a break of 5 minutes or so? You must be tired speaking so
no,
long.
madam,
It's
I
okay.
am
So
okay.
I will request Dr. Rita to, stop the recording and then restart the recording for the next session so that we have two videos. Otherwise,
So
the
let
video
us
will be long.
take a consent from the participants, how long they can be there, because next session
Okay.
again as you start it may go for.
So they can all write in the chat box how long they can stay here for the
Yeah,
next session. In the meantime, Dr. Rita, you can stop the recording.
thank you.
Please write in the chat box that if you can stay till 6 o'clock or you want to leave at 5:30, please write. So, sir, you are very popular. Everybody wants to stay except 2, 3 people till 1 hour. So, I think you can continue till 6.
Okay, madam. Yeah, we can.
So, Dr. Rita, when I think Dr. Lakshmi Prasad starts the session, before that, you can start the recording. Are you there, Dr. Rita? Dr. Rita?
So the audience, please understand it is our collective endeavor. Okay. So it is a mutual motivation kind of thing, yourself being there and ourselves with the platform that is provided by Madam and the RC team of New Delhi. That no, so the MBAHCM is quite a sought after course, and people earlier who have been opted for PGD diploma in health management PGDHM. Always they were wondering why it can't be master's course. So nice that under the leadership of Madam and the team, finally the batch has been started, and in one way or other way, we all the professionals, some of us, we are trying to get associated and to extend a required level of support and do justice. So maybe you must be knowing it is not a our main kind of thing when it comes to multiple responsibilities that each of us holding. You from your side, your end, you also from our side, we also. So that calls for coming from one meeting to next meeting and completing one task to other task. So that is always there. So, but the effort is there. So as you are, the best material that I ever come across is always IGNOU from my student days onwards. I did my MD in 97 to 99 from Nizam's Hyderabad. So there also hospital administration, not those many books are available. Books which are available, they are from 1960s and 70s. Megiboni, Mekicharan, Mekale, like that. Madam, is the recording is on?
Yes, sir. They didn't switch off the recording, so please continue. They will later on put it into 2 videos. No issues, sir.
Okay. So the second unit under the same block that we are dealing with now is about classification of law offenses and medical negligence. So the very title speaks of ourselves to cover some of the related aspects of patient rights, the kind of criminal kind of offenses that are possible in the healthcare related setups, and the kind of negligence. All the things we are expected to cover. Let us make an attempt. So legal aspects, every clinician administrator must know. Okay, whatever the malpractice related, because every profession calls for some level of caution and some level of code of conduct, and to be judicious. So let us see how it goes as per the material. So I've been provided the IGNOU material where I also been maybe contributor. So based upon the existing material, how the material could be converted into a kind of a lecture with using of the PPT and with all kind of chat GPT kind of provision, we are making an attempt. There are no big claims here. It is simplest possible attempt for the common good for all of us. So under this particular unit, uh, again, as per the IGNOU, its own kind of layout. So duties of medical professional. So when it comes to state, that is government, you are supposed to report MLC. Then when it comes to patient, you are supposed to extend the standard treatment with a consent. So duties of a medical professional. You cannot deny the kind of a emergency care. Then the classification law to that extent will be covering whatever we are supposed to be knowing to that extent. So key definition elements of crimes. So offense under IPC now, Bharatiya Nyaya Samhita that has come. So some of the important acts which were earlier IPC, and what kind of articles they are under, and BNS again, and what kind of how it has been adopted, that we'll be speaking about. The how the Consumer Protection Act uh, actually sees there's a medical negligence or not. There are the 4 Ds where there's a kind of a duty to other 3 Ds will navigate as we go through that particular side. So where negligence cannot be there, but it maybe people may be under that kind of impression. So how it could be delineated, that particular aspect may be there. Then rights of the patient, of course. A patient is not at the disposal of the healthcare provider. A patient is a kind of a person who is having every right, though he is taking, like we assert our rights while availing any other service or while buying any of the product. Likewise, here also the patient rights always prevails. Law of torts, that is actually came into in the format with the Consumer Protection Act. Otherwise, also it is there from beginning. That is nothing but the civil law. What are the 4 essentials? Vicarious liability, because hospitals runs 24 hours. So it is not that a junior most doctor is there, so we are not responsible. I have admitted my patient, left everything to somebody. It is not so. So you cannot say my building is been planned by one architect and constructed by one of the biggest firm L&T. Later anything mishap happens, this is not my responsibility. It is not so. As a owner or a director or managing director, as a management board, or a simple proprietor, or simple practicing doctor with your own establishment, it leads up to the top of the chain. So important case laws time to time, the judgments which have been. So these chapters are interrelated, and that's why they are under the one block. So some of the topics would be kind of a repetition to that extent, but in the context of the given unit title and the requirement, because unit wise if you are preparing, the title of the unit is something and your preparation is the content is not covered because it is covered in the previous unit, it doesn't make any kind of sense. So maybe nice that IGNOU is even today they are providing the costliest possible replacement in terms of hard copies to soft copies, though it is being done. I think still IGNOU is providing the hard copies. So the number of pages increasing means still it is affects bottom line in one way or other way, but still they are providing. So this particular unit, I think, it is having around 114 pages, covering 3 units alone. So there could be repetition, but the reason could be what I have explained just. So learning objectives, that is the first slide that way everybody everywhere one need to focus. The structured learning is always starts with what are the learning objectives out of the unit, what you will understand by end of class by the different branches of law, that is criminal, civil, or whichever way, let us see. Define medical negligence, 4Ds framework, identify criminal offences under IPC, under BNS, analyze rights of the patient and describe the legal defenses. So always it is a mutual kind of thing. It is not that somebody, it is alleged, it is been accused of. Unless the court, determines beyond reasonable doubt, you are always on safe side. So there's an element of defense which covers, which protects us all the time. So that aspect also it may be covered. Apply the concept of tort, vicarious responsibility, and res ipsa loquitur. So duties of medical profession to attend the sick, that is always there. So how during COVID, everybody else having a kind of all kind of duties, they are being outweighed not to attend, whereas all kind of leaves of our doctors and healthcare, not even doctors, we are talking about healthcare workers, HCW. It is no more doctor, nurse, everybody. Once you wear the protective, all kind of face mask and attire, the dress. So healthcare worker is a kind of a person who is providing the healthcare to the public in whatever capacity, in whatever establishment, under whatever situation. So the duty remains always same. That is, cannot refuse mid-treatment without arranging alternative care. Accept care is legally actionable. Abandonment after accepting care is legally. So once you take the patient, not only you should be completing and making him a hale and healthy or whatever dischargeable. If not, at least you cannot abandon. You can always give the kind of required advice and transfer. Duty of prognosis. So there's a kind of a reassessment. A patient is with you means you ask him to come after 7 days. If it is admitted patient, you are going to see him once in a day at least minimum. Even if you are a specialist, only MBBS doctors you employed, but the specialist who has admitted, so always they will be updating the prognosis to the patient so that he can always change his decision or he can stick on to his decision. So concealment of diagnosis is a breach of the duty of the disclosure. So whom to disclose the patient condition? When it comes to HIV, even if a spouse party comes, you have a kind of a duty to disclose, because not only the life of patient, the kind of a proposal related to his impending marriage or impending childbearing, wife, family members may need to know in some of the conditions. So COVID, what happened? The affected people houses are labeled by the revenue department. This house is the family members of that particular house is having COVID affected family member, isn't it? So the principle is larger good, maybe in one way or other way. Though prognosis, patient confidentiality is there, there may be exception also. There comes the duty of secrecy. Exceptions are court order, notifiable diseases, insurance cases, public safety. So under the public safety, everything been notified and people been alerted. Cannot abandon, that is already we dealt with. You cannot abandon a patient. There's a kind of a sacrosanct relationship, sacred relationship that cannot be given up just like that. Next comes to classification of law, civil law. It is all about just kind of compensation it is limited to. So there could be cases which comes under the purview of both and civil and criminal at the same time. Also the legal framework we are talking about, that is about again criminal law, where there's a kind of imprisonment or fine, where beyond reasonable doubt all kind of violation in terms of ethical practices, in terms of patient harming, everything being done, there may be criminal law may be applicable. So under which law to proceed with, that is the person who is aggrieved, that is his prerogative. After that, whether it is acceptable to continue under that particular law or not, either of these two things, that is again being decided by the court of law only. So because some of them being under both the purview of both civil and law. So duties of offences, this is all I think some of the kind of things which not into much of related to us. So we are talking about these two kind of things. First two. So healthcare law is some features. Civil law is there, criminal law is there, resolves dispute and compensate the victim. Civil law job is always, it is seen as a dispute. Dispute is always what? Your claim is different, my claim is different, and you have something to prove yours, I have something to prove my side, but one of us is being aggrieved. So the aggrieved person is said to be a victim. Okay, it is not a kind of a irreversible kind of thing. It is with a reasonable care, though still being extended, still the damage been happened. The damage may not be compensated in terms of restoring the life or restoring the limb or anything, but whatever reasonable doubt, reasonable kind of application of knowledge and everything, still it is there. So you may be asked to compensate. Then there's a kind of a complete negligence with a kind of you have done the surgery, but you have not taken even the post-operative care even for one day. So you have done the surgery, patient been discharged after 6 days under your own discharge summary being countersigned by you. Later something happened. That time a civil law may come. A criminal law may come into effect. You have done the surgery, but you didn't made any visit of post-operative visit or didn't advise any post-operative related care. But as per the standard treatment guidelines, it talks for monitoring these many things and these many laboratory investigations you should be doing, and these many kind of established protocol is there. Against that only a patient can be admitted or discharged. Nothing been followed. So there can be aggrieved party plaintiff for state or criminal law, can be by state or government, and even the individual can be. I think so. So burden of proof, balance of probabilities beyond reasonable doubt. Because criminal law, it is a kind of a imprisonment. These things are coming into picture. So for anybody to prove there's a crime that is being done, crime is always said to be. Though again here you can see the point initiated by state or government. Crime is though individuals are suffered, the crime is always seen is it is against the government, because against the society. Government is there to ensure the society is safe. The safe society, if it has been disturbed because of the act of commissioner or commission, by definition, it says the government is the ex party. So outcome is compensation, damage, injection. Injection is prescribing you or proscribing you. It allows you to do not to do practice further. That is maybe injection order. So here in fine, imprisonment or both. In the criminal laws, the case is proceeded. Finally, it may end up with only fine. Okay. So compensation is something you are compensating to the extent of damage. Fine is more than compensation. Fine is a punishment under criminal law. Okay. Fine is you have violated, for that fine is there. Compensation is there is a damage. So to the extent of damage, you are providing the compensation. So some minor difference I thought on those lines. So I am sharing my understanding. So healthcare, medical negligence suit, they can always go with that. So cause of death by negligence is the most common, 304A IPC, that is there. Healthcare, four key areas, there is a negligence by virtue of not providing the standard of care, or there is a 4 days which we are going to see in the next slide maybe. Then there is a kind of a evidence that there is no required care, that is RESISPA repeatedly we have come across. There is a required consents, the ethics, all these kind of things. There is a duplicate doctors are there who has done organ transplant. We have come across such a case in the media in the last week, I believe. Organ transplant also somebody quack was doing. So, a cockery, how much it is prevalent, you know. We are not talking about even registration. We are talking about mm, the people who are not qualified, they are doing. Then administration. So, a hospital is finally supposed to be the place where we practice our profession. So, as a hospital, as a physical entity, which is having all kind of infrastructure and number of people like you, me, and everybody being coming together as a team, and the bylaws and the kind of administration or management makes us to work in a particular way. So this all makes administration liable as well. So this is the healthcare law, or four key areas of applicable. So next slide. So they say there is 3000 BC onwards it is there, then Hippocratic oath, then you say do no harm. That is the first principle. No, Hippocratic oath also do no harm. So medical negligence means what actually? Medical negligence is your medical intervention, your whatever the clinical intervention, what you have done that led to harm, basically, isn't it? That harm also happened because of negligence, not because of mistake in a judgment. Judgmental mistake is always a kind of a thing that can happen while you are practicing profession. But negligence is not something. It is quite evident everything is there, still you didn't use your senses or the kind of infrastructure that is available. So Declaration of Geneva is there, physician oath by World Medical Association, Indian Medical Council Act time to time. So key definition, medical definition, all the things you need to look at from your side. So medical etiquette, custom and courtesy norms within the medical profession. So this talks about maybe within the specialty, most of the times it is one specialist against other, that may again lead to a kind of a situation. Elements of a crime, mens rea. So that may be Greek or Latin where it is taken from. What must be proven to establish criminal liability? So these are the things that are to be established. Okay, these are the four things. A legal person who can be held accountable under law. So we are a legal person because by virtue of our registered, because under the legal provision, we have registered ourselves. So we are a legal entity. As a doctor, why registration? Now you are under the ambit of the law. People always say there's a crackery there. People are without qualification, they are practicing. They are not regulated by anything except by the local police station or somebody when it goes to court. But we are being registered as a doctor and we are always under the lens. We are always under scrutiny. But why it is there? Because you got registered and you have a code of conduct, you have the requirements to fulfill. Mens rea, guilty mind, and whether what is that happened is because your action because of with the intention or recklessness, none of these things are acceptable. So you are registered, your actions are not nowhere acceptable. Then your action because of negligence or whatever your mental state or whatever lack of knowledge, does it actually lead to harm? Okay, luckily I have done this, so but nothing happened. God has saved me. A doctor may say many times, God has saved. Everybody will say in their particular line of profession. So it doesn't result any. So doctor has done wrong thing to me. That time he is supposed to see, he didn't see me. But does it lead to any harm to you? Post-operative, he didn't come, he didn't see me within for one day. But has it happened? That is your dissatisfaction. You may give in your feedback, you are not happy with the care that is being provided, the kind of revision which they are supposed to do. But it doesn't result in any harm. So everything plus, if everything, that harm has resulted into a kind of a perceivable injury that is having a effect on you. So harm is there, I believe, but it doesn't leading to a kind of a my mobility being restricted or anything, a kind of a tangible thing for anybody to understand that you suffered. Such injury itself is not there. Okay. So all these four things, if aligned, then you are there into a kind of a criminal negligence aspect is coming into. So intention, desire to bring about harmful outcome, knowledge, not having the required level of conduct or medical knowledge, recklessness, that is there, negligence, all the things. In medical negligence, the standard is usually negligence, not intention. So it is understood nobody will be having the intention to do harm. Once you say intention, that is actually attempt to murder kind of thing, no? Attempt to harm, attempt to injure. So that is different. Actually, nobody ever conceived there is an intention to harm. But there is a negligence that is leading to harm. Okay, so it is, so intention or no intention, no more discussion. It is all about whether the harm is resulted due to negligence. The doctor need not intend harm. Failure to meet the standard of care is suffice. This is important. Failure to meet the standard of care is suffice. So that means your whatever the NMC says, these many credit hours, you need to have been trained in ALS or BLS, whatever the kind of updates you are supposed to be attending. The administrator, while doing the interviews, say many of you may not be doctors who are the participants. You are taking this course. While you are doing your recruitment process, then you need to see whether the required knowledge is there by administering the required level of interview questions or written test. Also, the trainings what you are providing, like madam has inducted pre-test and post-test like that. So all the things makes the administration very much active part, whether you are a doctor or non-doctor. If you are into profession, you have to look after. So then offenses, you say section 223, failure to report. So MLC case is there, you failure to report. Doctor must inform police during MLC cases. So you have actually the law which governs the society by such harmful person being treated with you, and maybe in time if you didn't inform. So because of MLC, the something been not been uncovered and been you kept under the carpet for whatever reason. So neglect act reinfection that leads to infectious patient. You are not isolated. We talk about isolation word. So making environment insanitary, usage of medical waste disposal. So biomedical waste, if I don't properly segregate. So under section 270 of the IPC or BNS section under 271. Now you can relate how the laws are going to affect us. So under section 271, you can be sued for not having a proper medical waste disposal. I believe it is good enough. Anybody from the attendees, can somebody say they could relate our daily practices, our daily obligations as members of the healthcare establishment? Somebody is there to say respond. Okay. So again 304A we spoken about, 312 to 316 illegal abortions. All the things are medical termination of pregnancy. A hospital has to get registered. If at a undertaking abortion, then they have to abide by whatever the law says, up to which week, 16 weeks, whether you can do, or 12 weeks you can do, as per the under particular genetic conditions, whatever the difference. Then section 342, detaining the patients. So non-payment. Now as a manager, you can always relate. So non-payment, patient payment nahi kiya, then we have withheld his discharge. We confined to the bed, hospital. Not allowed. You stabilize the patient. If you allow the patient in the beginning itself, based upon patient finance condition, that is okay. If the patient is under one scheme, you are claiming the reimbursement under scheme, that is okay. But after the treatment is completed, if patient is fit to be discharged, just for want of your money, you cannot. That is the beauty here. So you have to go to the court. Under civil law, you have to claim the hospital bills where the undertaking is given at the time of admission by the patient. All the charges he will be pay in advance, or some of the balance which is there, he will be clearing before the discharge. So that undertaking is there. So that is again a consent to clear the hospital bill. Still, if he doesn't know, do that, still you cannot confine the patient to the hospital. You have to discharge. Okay, that is the implication here. So duty, so you have taken the fee, you have accepted the patient, you registered the patient, so automatically you are duty bound. Then there is a deficiency, conduct fell below adopted standards. So you didn't see periodically the required medication, you didn't administer investigation, you didn't ask for a patient come with the head injury, then you thought you don't even require CT scan. So maybe the standard of whatever the clinical examination may ask you as per the guidelines, maybe you would have taken the support of CT scan, at least that is documented, and patient would have denied that, and that is also not been done. You even didn't ask for the CT scan itself. directly this led to a kind of a harm, and that led to a kind of a further damage. All four elements, the previous slide only given in other part. Legal framework for proving negligence. Medical negligence is the failure of a medical profession to exceed the standard of care, skill, and diligence that at a reasonable professional would exercise in similar circumstances, resulting in harm to the patient. So I think it is very clear. All is for legal duty. Breach of duty is there, then there is a breach of duty. That breach of duty is causing the harm. So directly. So what is the harm and what is the duty that you didn't fulfill? There is a connection. That is the causation. This green one, this breach only led to this kind of final damage. The second, this one, and the fourth one to be connected by beyond with another medical professional to say so. By legally it is establishing so. All four of them must be proven. If anyone is absent, non-negligence claim fails. So that's why not those many cases are there. Okay, theories of negligence by commission, by omission, all the things are there. Required test, wrong drug administered, overdose given. That's why NABH, all 6 medication management, okay, right medicine to the right patient in the right dosage, the right way of administering at right time. So all these 6 hours, right, wrong drug administered. So incidents and sentinel events, if we are talking about hospital has to document so that not for the punishing, for the training purpose to correct your systems. So these are the few things in the commission. Omission is so fail to order. CT scan we talked about head injury patient. Did not you given doing everything, but you are monitoring the vital signs. You are just connecting with the monitor just to collect the fee of under 500. Patient is connected to the monitor, but you didn't do the required intervention based upon the vital signs. So what is non-negligence? Volume test is the internationally referred thing which is changed the very discourse on the negligence. No negligence if doctor follows the accepted practice of a responsible body of medical opinion. So ophthalmologist association is there, some dermatologist. So all these associations they come out with acceptable practices which are documented in their proceedings or in their journals. So at least to that extent, if you do, it is not about the outcome, whether it is a standard practice. Outcome is bad if you are punished. No doctor can practice, isn't it? It is not about the outcome. It is all about the how you administered, how you are practicing. Okay, unexpected results always it can be the bad outcome of a properly performed procedure, not a negligence. This is the golden rule. It is never worry about the outcome. But what happens? Mob is there, so people attack on the hospital based on the outcome, based upon your billing this one. So there comes people to have a kind of all kind of contacts with police stations, all the things like any other establishment. That is the reality. Wrong diagnosis, incorrect diagnosis alone is not negligence if proper care was exercised. So if diagnosis is again a opinion only, you thought based upon this result with a reasonable kind of knowledge and everything, you have come to one diagnosis. That's why there's a always differential diagnosis is always one will arrive at. So if 10 differential diagnoses are possible, one of the diagnoses, if you, because of the evidence that you thought of, if that is wrong, still it is okay. As long as care is exercised to that diagnosis to that extent. Unavoidable accident. So unforeseen, act of God. So this last green one, act of God, unavoidable action. These do occur. Unavoidable complication is not a non-negligence. So all the thing key defenses, informed consent, standard of care, contribute to negligence by patient. You should say to you inform the patient to do all this kind of immobilization. POP removes the very next day. You said immobilize by 4 weeks or 6 weeks. So he doesn't do that. So monitoring medication is not taking. So monitoring of blood glucose is not being done by the patient. So all the things there gives a lot of leverage for the medical professionals. So because all are party to the from patient side also a lot of complaints is there. No causation between act and harm. So whatever you have your act of commission or omission and final harm, if there is no reasonable connection is not there, automatically you are not responsible, negligent. Professional judgment. So it is a medical practice. Two medical practitioners of general medicine may have different opinions. That is always acceptable. So High Court says something, one bench, one judge, single bench. Then other bench, two benches, two judges bench will give some other judgment. Then the case go to Supreme Court. There could be some other judgment. So all the things in any kind of a profession, difference of opinion is always possible. So emergency, necessity, defense. So with the required limited kind of thing as emergency. So in the good Samaritan kind of thing, patient only refuse treatment, so you are not liable. So rights of a patient, right information, right emergency care, right confidentiality. Second opinion, patient can have rights of record, report, human dignity. All the things speaks for themselves. So law of tort, four essential. So already whatever we spoken about, duty, breach, causation, damages. So all the things are there. So vicarious responsibility, hospital is liable for acts of employees, doctors, condition. Act must be within the scope of employment and during working hours. Whatever that you are doing, that is within the scope of if your employment, if you are done, that is again your responsibility of the hospital. Out of the, our one of the learner, the participant, our esteemed participant, he was asking, so what is the institution wise, what is the individual wise when it comes to indemnity insurance? So your employee, your job description, you are supposed to do all the things by virtue of your qualification. So if you do something beyond that, out of your own interest, not being asked by management, then you are responsible. Within those duties only, if you are responding, if you are doing then automatically the responsibility goes to superior. The employer is responsible for negligence acts of employee done in the course of employment. So job descriptions are essential. Independence contractor, hospital generally not liable for the acts of visiting consultants. So he is a visiting consultant. So hospital is only holding the patient on behalf of the doctor who is primarily responsible. So there is always sometimes there is a kind of awarding the penalty. They give some percentage. Hospital is 40%, consultant is 40%, 20% is nurses. Like that, nurse is giving wrong injection, doctors are the hospital is liable. So nurse is again employed by three element. They're not orderly. So in the common way, this kind of outcome not supposed to be there unless there's a negligence. Uh, so there's a kind of executive control. The instrumentality was so the hospital is not providing required level of PPE to the doctor, required level of diagnostic support. So many of you being entrepreneur, they can think about these lines. Okay. So plaintiff had no contributory negligence in causing the accident. So whatever it is. So surgical instrument left inside the body, wrong limb amputated, burned from hot water bottle. All the things lead to the superior kind of because the system, the hospital owner or whoever is there, they have to establish a system, safe system. It should not depend upon one single employee. There comes your superior. As a system, you fail to establish, automatically you are also responsible as a proprietor or whatever. Negligence is so base that no further proof is necessary. So when there is a burden of proof, usually as I told, in the all kind of medical related, it is the party which is accusing you, they have to prove. But when it is kind of ISPA lacutar, wherein the something related to surgical instrument left inside the body, wrong limb amputated, so you have to prove that you are not negligent. So repeatedly, if the patient says he is having a problem with the right leg, but he is always given in writing everywhere that he is left leg only complaint. Consistently, he record and his own statement shows so. Sometime later, he changed actually my problem is with my right limb, whereas my earlier record says so. But your own history, your own consent, everything being there, then you can may use it as your defense. Patient also party to culpable kind of thing. So So several laws are there. Jacob Matthew. So gross negligence required for criminal liability if is to apply. So Kunal Saha case says why the hospital is responsible. Where 6.08 crores, highest possible amount that has been for the first time at the Emory Hospital. Kunal Saha happened to be a doctor he himself, I believe so. So different cases are there. Even PGI Chandigarh involved. So I believe these things will come into you, the IGNOU related videos which they make access to all of you. So spend the required time and go through because they speaks for the content. So legal liability, Contract Act, Tort of Law. So criminal liability now under IPC. Apart from that, new B this Bharati Nyaya Samhita. Then anyhow Consumer Protection Act is there. That is again it has a kind of a judicial kind of powers too. Then one can go from consumer court to regular courts. Consumer Protection Act, under that you have the provision again to go to the regular court. A single act of negligence can simultaneously attract civil and criminal and consumer liability. All three cases can run parallel. So medical, all the things, medicine as a service. So key takeaways: medical negligence 4 days repeatedly we talked about, civil negligence, hospital versus workers responsibility, consumer forums are powerful. So they redefine the amounts also, up to 5 crores also. Now consumer forums they can award as a consumption kind of a compensation. Consumer forum is not for litigant. It is making the speed time-bound justice. It is accessible with a exclusive kind of provisions wherein the regular courts being burdened with, and which the things can be again appealed in the regular courts. So this is the end of slides. So any kind of discussion is always welcome. Apart from questions, please.
Sir, I have a question.
Yeah.
Sir, where does hospital acquired infection fall? Like, under which type of negligence?
No, we talked about isolation in one of the slide. Say isolation is nothing but hospital infection prevention spreading from healthy, kind of person who could be the source of infection to the regular person. So you have a kind of a establishment, the management support to have a system. You should be having a proper CSSD, which is having proper kind of all kind of equipment and quality control and microbiology department again part of running your CSSD. That kind of system you didn't establish. It may establish as a management it is failed. So the vicarious responsibility is always coming to the hospital, whoever is running. So individual practitioner, they can always say they have a kind of a they themselves is you have monitored some kind of patient. There's a doctor himself is having a fungal infection. Doctor himself is having. He was treating patients in the NICU. And over a period of time you saw you have hand hygiene practices are good and everything is good as per your IPC infection prevention control committee is supposed to be there. Hospital infection is a kind of a iatrogenic. No, it is because that is occurred because there is a negligence being there in the environmental kind of related negligence and the kind of service extension and service maintained. So the related aggrieved party can always can prove this led to this kind of you have a recall records. Say CSSD has to see batch wise the issue in one autoclave cycle with the capacity of say whatever the liters, maybe 60 liters or 100 liters, whatever the specifics could be. So accordingly entire batch one been issued, that entire batch whichever the surgeries happened at that particular window period, if all the patients caught the infection, then again that is a kind of negligence only. So I mean to say the scope for the infection is very much there to get attracted the required, the punishable and whatever uh, the provision of the law. So it is very much covered under the law of torts. It may not be criminal offense, but under civil for sure, which lead to compensation.
Thank you, sir. So also one more thing. Does death only qualify for criminal law, or any other kind of damages are also in that?
No, criminal law, I believe it is a kind of a application where the permanent damage are, it is not only the intensity of the damage, could be the intensity of the negligence over a period of time. Say somebody has become brain dead over a period of time. Somebody life quality, it is quality of of patient, individual patient is completely been affected for the rest of the life. So criminal law, you a patient is coming to casualty emergency. So first is it is a simple injury or grievous injury that you are going to certify. You are going to certify. Once it is a grievous injury, the applicable kind of provisions may be under the criminal law. So likewise, it need not be the death alone. So maybe one of the slide it says 304A, it is in the bracket, it is mentioned death. Maybe that to be revisited for the clarification and correct answer's sake. So I believe it need not to be death alone for the criminal act of negligence. The negligence that would not have been led to death also, I am saying that led to a kind of a permanent and total disability kind of thing. That is also part comes under the criminal offense only.
Thanks a lot, sir.
Please, yeah, we need to we need to revisit because in the process we learn. Madam or anybody from DMC? No, that is regional center New Delhi. If somebody is there,
Yeah, sir. Yes.
madam, please give us next course of action. Shall we complete third one so that the block is completed? That any
So,
given day it will be like this only.
so everything is complete now, isn't it? We can go ahead and close the class.
No, third unit is there. Maybe we can
Oh,
complete
sorry,
in.
sorry, sorry. Third
Uh,
unit is there. Yes, sir.
yeah,
So we can quickly
third.
take it up, sir. Yes, sir. No problem.
Okay, so we are going ahead with the third unit.
Yes,
The
sir.
third unit is about laws and acts that are applicable in healthcare organization. It is more of the licenses. It is the easiest part which you can always relate when it comes to the all kind of acts that day in and day out. This is what making hospitals in one way or other way non-sustainable. If